Minhas amigas e meus amigos, eu volto mais uma vez pelo Warde Advogados, mais um seminário do nosso ciclo de palestras sobre arbitragem. E no dia de hoje nós recebemos uma estrela internacional, talvez aquele que seja considerado, e de fato é, o grande nome da arbitragem no mundo. Não é? Há 20 anos ranqueado no topo de todos os rankings em matéria de arbitragem, um advogado famoso, mas também um doutrinador que treinou gerações de arbitralistas no mundo inteiro, Gary Bourne. Gary, how are you? Thank you for being with us.
Thank you, Walfrido. Thank you very much for having me. It's a pleasure. It's a pleasure and an honor to be here.
It's our honor. Eu estou aqui também com o meu querido amigo e sócio, Renato Polillo. Renato, tudo bom com você, meu querido?
Tudo bem, Walfrido. Um grande prazer estar aqui hoje com você. And Gary, it's also a pleasure and an honor for us to have you here. Thank you very much.
Thank you.
Apenas para esclarecer aos nossos espectadores, nós vamos fazer perguntas. Na realidade, o Gary vai fazer uma preleção inicial e, em seguida, nós vamos fazer perguntas ao Gary em inglês. Tudo que for dito em inglês, seja por nós, seja por ele, estará traduzido por legendas. As legendas vão aparecer aí na transmissão. So, Gary, we'd like to hear about the connection, the relation between arbitration and the pandemics, the COVID-19. What do you have to say about that, please?
Well, this is a topic that's both timely and important. It's odd in a sense. If you thought back 3 months or 5 months, you couldn't have imagined either us having a webinar like this or international arbitration being conducted in a virtual setting. And yet here we are, and here international arbitration is being conducted very frequently without physical meetings in a virtual setting. I think big picture, one of the fascinating developments over the past months has been that although life, ordinary day-to-day life of most people has been disrupted enormously, international arbitration in most respects hasn't been disrupted at all. Arbitrations continue to go forward. Arbitrations continue to be filed at leading arbitral institutions, and hearings, which in some ways are the most difficult aspect of the arbitral process during the pandemic, continue to be conducted. There are, to be sure, differences. Filings of arbitration requests occur in different ways. Case administration occurs differently. And perhaps most importantly, hearings, so-called virtual hearings, are conducted in a quite different way. Nonetheless, the arbitral process continues and continues as it historically has to provide efficient and enforceable results. I think in these opening remarks, I'd like to say a few words about what's probably on most people's minds. They've no doubt heard in other webinars or read about so-called virtual hearings, but it's still worth, since in some ways these are so new, me addressing them at the very outset. We've all done pre-pandemic, before the pandemic hit, we've all done remote witness testimony, cross-examination of witnesses, sometimes by telephone, more frequently in the last years by video conference. We've all sat in a conference room with the tribunal and opposing counsel and cross-examined a witness who appears only on a video monitor. That has its own technological challenges, but tribunals have ordered it frequently when a witness, either because of illness, because of visa issues, because of other problems, cannot be physically present. The only way to examine the witness is by video conference, and tribunals have ordered that. Parties have cooperated in remote witness testimony. And in some ways, when you think about virtual hearings, perhaps one's first thought is, we've done that already. but actually a virtual hearing is not just a little different, but a lot different than remote witness testimony, because in contrast to remote witness testimony, a virtual hearing involves nobody in the same room, typically involves nobody in the same room. Just as we all here are in different locations, often different time zones, in a virtual hearing, all of the participants, all of the members of the tribunal, all of the counsel, all of the witnesses are usually at home or conceivably in their offices, in front of their computers or their webcams, participating virtually, participating remotely. And that is a very different experience than when one cross-examines a witness remotely, and in particular, when one attends an in-person physical hearing where everybody is in the same conference room. Questions are raised as to whether a virtual hearing can be conducted over one party's objection. There are some authorities who suggest that the answer is no. They suggest that the answer is no, either because parties are entitled to a hearing if they request one, and a hearing means, as historically was the case, a real in-person physical hearing where everybody's in the same room, or alternatively, that parties don't really have an opportunity to be heard if they aren't in the physical presence of the tribunal, if they can't cross-examine a witness with the tribunal watching. At least thus far, I think most arbitral institutions, most tribunals, and I'm fairly confident most national courts have not been impressed by either of those two arguments, at least as a matter of principle. I think the concept of a hearing encompasses, in the eyes of most authorities, a real-time video and audio connection, an opportunity to hear the tribunal's questions in real time, to cross-examine a witness in real time, both by audio and visual mechanism. But it doesn't necessarily mean an in-person hearing. You can have a hearing where the parties have an opportunity to be heard in ways other than sitting in the same geographical location. And I'm fairly confident that most national courts will come to that conclusion, in particular because in many jurisdictions, national courts are conducting their own hearings in precisely that same virtual manner. And it would be ironic, it would be wrong if national courts said that although they can have a hearing virtually, other means of adjudication like arbitration cannot do so. For the same reasons, I think an opportunity to be heard can be provided by a virtual hearing just as it can in person. Technology obviously enables us to communicate, seeing and hearing one another in real time, just the way we're doing now. Witnesses can be examined about documents which can be displayed. Internet connections and time zones can be issues, but in principle, as countless virtual hearings that have been conducted over the last couple of months demonstrate, parties can present their cases quite effectively, can examine witnesses quite effectively, even if it's remote. It may be a different experience, it may not be identical, but in terms of providing an opportunity to be heard, in principle, there's no reason that a virtual hearing cannot do so. Of course, there may be exceptions, just as there may be exceptions with an in-person hearing. There may not be internet connections in some regions. Time zones may make it very difficult to conduct an effective virtual hearing if you have people 12 or 15 hours apart, and one counsel would necessarily have to stay up all night or get up at ungodly hours. But apart from those unusual circumstances where a party might be denied an opportunity to be heard if a hearing were conducted remotely, in many cases, a tribunal can adapt the procedures that we're familiar with to allow for a virtual hearing. One of the things that I think it would be interesting for us to speak about in a little more detail, though, are the practicalities, the technicalities of how a virtual hearing, assuming you can have one, is actually conducted. I've done several by now and have some personal reflections on how one might do it, what pitfalls to avoid. But with that as an introduction, perhaps we can move to some of those details.
Thank you, Gary. That's very important. But before we go further on the problems and the solutions to the consequences of quarantine, I'd like to use your experience to understand how you foresee the changes in the contents of arbitrations, future arbitrations, and if you foresee a wave, a big wave, a tsunami of arbitration after quarantine, after we go back to normal life, considering we are doing that in the next few months?
That's a great question, and it's one I know many people, clients, arbitrators, others are asking. My own personal view, apart from observing that I have no crystal ball and therefore can't be sure about what the future will hold, my own personal view is that, firstly, we can draw some conclusions from the fact that arbitrations have continued to be filed almost in record numbers during quarantine. That means that at the very time that law firms have dispersed their staff to their homes and clients have done the same, disputes are arising and arbitrations are being commenced. The same is true, of course, of litigations. But at least with respect to arbitrations, and notwithstanding enormous budgetary pressures on companies in some sectors, disputes, historic disputes, continue to be submitted to arbitration. To your question, secondly, as to what to expect when lockdown ends, I expect not so much because lockdown has ended, but because of the economic consequences of lockdown, that there will be, if not a tsunami, at least a quite substantial increase in the number of disputes. The economic dislocations that have resulted from lockdown in countries all around the world will necessarily produce disputes. The economic dislocations mean that companies will not want to fulfill their contracts, that the prices of particular goods will have changed dramatically. And as past experience teaches us, those kinds of dramatic dislocations, of substantial unforeseen changes, almost necessarily produce disputes. And I do think, therefore, that as lockdown ends, or as it continues in some different form, we are going to see, both in terms of arbitrations and litigations, a quite substantial increase in caseloads compared to the historical figures.
Let me go on with this question. Do you think that considering arbitration and arbitrators are a limited number of people, do you think that arbitration will be able to cope, to solve all those new fights, those new litigation that will come in the future, imagining that we will have a worldwide problem with public contracts, private contracts, corporate fights, and so on?
I think that's a good question, but as historically has been the case, I think arbitration is almost infinitely flexible, and that it will adapt itself to whatever the precise nature of the changed circumstances may be. There are, fortunately, because of the increase in the number of young arbitrators, there's a healthy pool of arbitrators from which parties can select. Because of the increased competition among arbitral institutions, there are a number of different choices that parties can make for institutions to which they might submit their disputes. Because of the increased competition among law firms, there's a surfeit of capacity in terms of representatives for parties in cases. And so I think there certainly will be adequate supply to satisfy whatever the demand is in terms increased cases. I think at the same time, although there are negative aspects, obviously, for arbitration from the pandemic, there are also positive aspects in the sense that virtual hearings and digitalized arbitration provide some efficiencies. I think one has to be careful in assessing whether some things that look like efficiencies really are efficiencies, but I think there clearly are aspects of virtual hearings and virtual arbitrations that can enable arbitrations to be conducted in appropriate circumstances more expeditiously, more efficiently, and that too will ensure that there's sufficient supply to meet the enhanced demand.
Great. Thanks, Gary. Great. I think Renato is anxious to make his first question.
Sure. Gary, as I know that you have served as a counsel in over 700 cases, I'd like to ask you a more practical question. I'd love to hear your thoughts in terms of strategy on the advantages and disadvantages of commencing an arbitration at this moment. What do you think? Is it a good idea?
Question. And I think in many ways, the same strategic and tactical considerations that always existed continue to apply. And I'm not sure that this moment, in the sense of the pandemic, changes the underlying strategic and tactical issues that a client or counsel face. I think arbitral institutions continue to accept filings, typically electronically only, but that, frankly, is almost completely irrelevant in terms of counsel's strategic decision about whether and when to start an arbitration. Question of whether you send it only by email and zip files or in hard copy is neither here nor there. Tribunals continue to be appointed, notwithstanding the pandemic, in almost identical fashion to the way prior to COVID-19. And therefore, I don't think the changed circumstances that we face really alters the underlying question that counsel has to address, namely, is this a case that's worth bringing? Or do the benefits outweigh the costs? What's the likelihood of success? How will the counterparty view this? One might take the view that counterparties, perhaps tribunals, may be distracted by the pandemic, and therefore this may not be an opportune time to initiate an arbitration. But I actually think that the business world has adapted, the legal world, the arbitration world has adapted quite well to the changed circumstances. And if you start a large arbitration against someone, it will get their attention these days just as fully as it would have obtained it in this time last year. And therefore, I don't think that in terms of commencing proceedings, one ought to wait or not wait based on current conditions.
Okay, great. You know, Gary, I've taken part of arbitrations, taken part of virtual hearings as arbitrator and as an attorney. And I don't think it's the same, you know, it's different. Mm-hmm. You don't get the reality and all its perspectives, you know. You don't feel, you know, the tension exactly as it is. You don't feel, you know, the expressions, the body, you know, movements, the reactions, and sometimes you may have a technical problems that don't let you quite understand all the arguments perfectly. Don't you think that's a problem? Don't you think that we should, you know, take countermeasures to that? And we could also face, don't you think that we could also face problems of validity of awards in the future?
Those are good questions, and there are certainly issues that others have raised in various ways. There's no question but that a virtual hearing is different than a hearing in person. I think in particular, cross-examining a witness virtually is a very different experience than doing so in person. I think that counsel's ability, if I can put it this way, to read the tribunal is much different in a virtual setting than in an in-person setting. Even with the most careful adaptation of technologies, I think one doesn't have, as you put it, quite the same feel for the tribunal and also for the witness that one does in person. I think there are ways to try to address that, of course, through technology. And I also think that we as lawyers are adaptable. I think part of the reason that virtual hearings seem so different is because we've never done them before, even if we've done 3 or 4. And as one does more virtual hearings, they, I know from experience, become less unusual, less unfamiliar, and one adapts to the changed circumstances. I think some basic technological steps enhance the virtual hearing experience, and these are not particularly original or creative suggestions or observations on my part, but I think as we all know, one screen, especially one laptop screen, just won't do it for a virtual hearing, particularly for counsel. If you're counsel, 3 screens are probably a minimum. You need a screen for the witnesses, a screen for documents, a screen for your own team so that you can communicate internally, and perhaps a screen for the tribunal as well. Because one isn't there in person, one needs to find ways to obtain the stimuli, the input from the virtual hearing to replicate in some way what it is that you would have had in an in-person hearing. That said, I think when one looks at the information that's conveyed by a virtual hearing, it can be almost as good, arguably, I've heard some arbitrators say better than an in-person hearing. You have the witness's face blown up in front of you on, if you have a large monitor, a relatively large monitor. Facial expressions may not be less easy to see, but in fact, easier to see because of that. You may not have the same degree of intuition about body language, but there are studies that suggest that one's intuitions about body language, in fact, aren't all that accurate. And perhaps, therefore, you've filtered out some noise by having a virtual hearing. My own experience is that the combination of time lags, of having a smaller image of the tribunal, the issues that arise from speaking over one another and the need to pause, change the flow and the dynamic of a cross-examination significantly. I also think that the issue of fatigue or exhaustion from seeing both yourself and the witness projected on a flat screen that you have to stare into affects us in ways that we're still trying to understand. I know from personal experience that an hour-and-a-half long cross-examination seems more exhausting virtually than a 3 or 4 hour cross-examination in person, even though the latter is also difficult. My own view is that these differences don't, in most cases, provide a basis for challenging the validity of an award because there was a virtual hearing. Things are different, but you've still had an opportunity to be heard. In the sense that both parties are subject to the same unfamiliar circumstances. There can be cases where, because of a technological imbalance, because of technological malfunctions, because of time zones, one might be denied an opportunity to be heard in a virtual hearing. But I think in most cases, just as in most physical presence hearing cases, parties can get a fair and full opportunity to be heard, even if it's virtually.
Great. Renato.
Oh, thank you, Gary.
I translated your name in English.
That's
because
perfect.
in Portuguese it's Renato, but in English it's Renato.
Yeah, your pronunciation is great. Thank you. So Gary, I was wondering if this current situation could be the turning point in bringing the online dispute resolution, the ODR, to the field of international arbitration. Do you think that it would be possible?
I think that's an excellent question, and I think your suggestion is probably correct. Again, none of us have a crystal ball, but listening to what clients say, listening to arbitrators, seeing my own personal reactions and experiences, I think that virtual arbitrations, online dispute resolution, will continue even when lockdown ceases to continue. I think that virtual hearings, in some cases, not all cases, and I would emphasize that, not all cases, but in some cases, virtual hearings have efficiencies. If you have a small value dispute with parties in different parts of the world, the cost of a physical presence hearing, which may only be a couple days long, often outweighs the amount in dispute, or at least is highly inefficient given the amount in dispute. A virtual hearing provides an obvious solution that isn't just an adequate substitute, but in those kinds of cases is a better substitute. You can resolve a dispute like that, a small value dispute with parties that are widely dispersed, where you don't need a particularly long hearing. I think that a virtual hearing provides a real opportunity for cost savings and a better form of dispute resolution. That said, I don't agree with what you sometimes hear, that virtual hearings will replace in-person hearings, or that they are necessarily less expensive than in-person hearings. It's true, an in-person hearing in some cases requires airfare and hotel accommodations. It requires the cost of the physical premises. But the most important expense, by far the largest expense in a major hearing, aren't those sorts of logistical matters. Instead, it's the time of the client, the time of the lawyers, the time of the arbitrators. And I think one then needs to ask, for a major dispute where parties really care about the tribunal hearing all aspects of the dispute, is a virtual hearing cheaper or more expensive? We all know what the virtual hearing exhaustion factor or fatigue factor is. Tribunals realistically can and will only sit 4 or 5, sometimes 6 hours a day. My own experience is tribunals push back if they're asked to sit much more than 4, 4.5, sometimes 5 hours, and they do so with good reason. As I mentioned previously, virtual hearings can be very draining, exhausting, and therefore a virtual hearing can't be conducted the way an in-person hearing can, over a concentrated, significant number of hours every day for a concentrated period of time. They take longer, necessarily more days. And if that's true, then the lawyer's time itself is likely to be increased. And as a consequence, a virtual hearing, which needs to take place over, say, 4 weeks, instead of an in-person hearing that takes place in a more compressed way over 2 weeks, may actually be more expensive, not cheaper. And as a consequence, I think one needs to think really carefully about, as lockdown ceases, what the most efficient way of conducting a hearing is. Just because we now have the technology and will be using the technology to conduct virtual hearings in some cases, doesn't mean that it will make sense to do so in all cases.
Great. Do you think that the current situation improves the opportunity to use or to ask for interim relief procedures? And also, if we will have a new normal using virtual hearings for those kinds of relief procedures?
That's a really good observation, actually. At the Singapore International Arbitration Center, we've had a number of emergency arbitrations since lockdown. Those, for whatever reason, I'm not sure what exactly the reason is, but there's been a particular demand for emergency arbitration, and they have been conducted just like this webinar, virtually. I think your observation that one may learn skills as a consequence of the lockdown, that can be applied to emergency arbitrations or applications for interim relief after lockdown is exactly right. I think that the experience of emergency arbitrators and tribunals hearing applications for interim measures strongly suggests that post-lockdown, that will be the most efficient way of doing things. It eliminates the need for scheduling, where travel and other issues, whether it's visa restrictions or simply the time taken to get somewhere, are an issue if you have an application for interim relief, an urgent application for interim relief. I think that the possibility of a Zoom hearing or some other form of remote hearing, which typically in the case of interim measures is only going to be a day or two in any event, is much more likely. And the things that we have learned as a consequence of the pandemic will be applied to good use after lockdown ceases.
Renato.
Gary, in terms of, in addition to the virtual hearings, what are the other stages of the arbitration that were impacted by this pandemic? Like the way how the tribunals deliberate, case management by the arbitrators. Do you think that we will get some improvement on these different areas of the arbitration of this pandemic?
Yeah. Looking at things from the perspective of counsel first, I think one of the biggest challenges is putting together a case as counsel. Historically, you could fly, you often did fly to your client's premises, you'd interview witnesses. Sometimes you'd interviewing people that you hadn't expected to interview. You'll have identified, been told you should talk to witnesses A, B, and C, but once you're there in person, you'll find out that actually witnesses D and E are more important, much more important than the people you thought you would talk to. You'll review documents. Increasingly, electronic documents are what one would review, and that could be done remotely, but hard copy still exists, and being at the client's premises, talking in the flesh to the client's representatives was an essential way of putting together a case. Talking face-to-face as well was often essential to make sure there were no miscommunications, make sure that you understood exactly what the client's objectives were, exactly what the evidence was. And all of that today is often impossible. You don't fly anymore to the client's premises. The client doesn't come to your offices, and therefore you need to put together a case, including interviewing witnesses, including reviewing all the relevant documents, making sure that you've had a chance to see the relevant documents remotely. And that presents real challenges. Even within a law firm, organizing your team, not being able to have a team meeting, not being able to walk down the hallway and talk to an associate or a partner, a colleague of yours working on the case face to face on a spontaneous basis is a big change. Of course, there are substitutes for that. Of course, one has Zoom meetings with clients, Zoom meetings with your team, but just putting together a case involves new challenges that didn't previously exist. Likewise, making a major submission. Make sure you've reviewed the documents, making sure that your bundles are properly put together when you can't page through the hard copy submission that you're going to make, when everything needs to be done remotely, and done remotely by a team that's all at home in front of their laptops is an enduring challenge. I think arbitral institutions in some ways have had it easiest. They've been able to accept online filings. SEAC and other institutions do that. Online filings that lawyers put together, counsel for parties put together, and cases can be administered by email, just as historically they tended to be done. When you think about the administration of an arbitral institution, it's conducted almost entirely by email correspondence and by telephone, and all of that happens pretty well in pandemic conditions, as it happened prior to lockdown. Arbitral tribunal deliberations are an interesting one. In my experience, they often, the important parts of those deliberations often happened at the hearing. Sometimes not formally titled deliberations, but the coffee breaks, the lunch breaks, the sitting together while you're waiting for parties' counsel to appear. All of that was a period in which real deliberations would take place. And now, in a virtual environment, that doesn't happen anymore. And you certainly can't get together in a conference room the way that historically a tribunal would deliberate. Nonetheless, you have your Zoom breakout rooms, and you can have Zoom calls among the members of the tribunal, which deliberations can take place. I think that for the most part, those aspects of deliberations can be replicated. What's particularly difficult, though, is the communications between the tribunal members at a hearing. You'll all about with how a tribunal eases back from their microphones and whispers or passes notes during a hearing to deal with some issue or make observations about a document or something of the sort. All of that needs to happen in a different way in a virtual environment. To some extent, one can have private chats and breakout rooms and the like, sometimes a separate WhatsApp line that or group that enables the tribunal to communicate. And that's why you see people sometimes not paying so much attention to Zoom and instead looking at their phones. But all of those are substitutes. I think my own view is that one needs to adapt to those substitutes, and if one does so, they will prove to be pretty adequate alternatives to what we were historically used to.
Great. Renato, is there any other question you'd like to make?
No, I'm totally okay, Walfrido. Thank you very much, Gary. It's a pleasure talking to you this morning, and look forward to see you in person very soon.
Yes,
so, Gary,
look forward as well, and thank you so much again for the invitation. It's always a pleasure to see both of you.
Thank you very much. We, are your fans. Love to hear from you and love to read your books. And it was a great honor and great pleasure to all of us. Thank you so much.
Thank you again.